we're running very early today. Mark Westcott here with Juanita.
Good morning. Good morning, Mark.
Great to have you with us. Once again, I'm out at Mitchell today, so from downtown Mitchell Motel, and Juanita, warm and cosy, no doubt, in Brisbane. So anyway, great to be here today. Apologies to anyone who was hanging out till 4 o'clock to see this, but due to other meetings and movements, we brought this forward to earlier today. But today we're going to cover off, and Juanita has some great issues that she wants to talk about this morning. So let's fire away, Juanita.
Great. We're going to talk today about some of the myths about wills. So 6 of the top myths that people have about wills. So we'll jump straight into it, Mark. The first one, which a lot of people don't realise or have a perception, is that I'm married, so I don't need a will. So probably the first thing I would say here is something that a lot of people do not realise, is that marriage actually revokes any existing will you have. So what that means, if I did a will today, then trotted off next week and got married, unless I have specifically made that will in contemplation of that marriage, my previous will is revoked. It's torn up. It's not effective. So a lot of people don't realise that, and then after their marriage think that while they're in the bliss of post-wedding, marital bliss, they actually don't have a will, which is a bit of a scary prospect. But the reason why you do need to address that and put that in place is that because that will may have been revoked, or you may have never done a will, what actually happens if you pass away is that your estate is distributed pursuant to the law, so the formula that the law provides on intestacy. And that might not be what you actually want, particularly if you have minor children. So the law says that in Queensland, if someone passes away without a will, then their estate is split up by a formula between their spouse, which also includes a de facto spouse, and their children. So specifically, if you had one child, the spouse would receive the first $150,000 and the household chattels or goods, and half of the rest. And the child would receive the other half of the rest. If there's more than one child, it becomes 1/3, 2/3. So the problem specifically here is that if you pass away without a will, you can leave your spouse behind having to, for example, share ownership of a house with minor children, or perhaps take the house and have to give all the cash to the minor children and not have that income stream. So practically it can be really, it can cause real difficulties for the spouse that's left behind. Also, of course, if you don't have a will, someone has to apply to be administrator of your estate. So these are the reasons why after you get married, you really need to make sure that you have an effective will in place to avoid all those issues down the track.
So just on that, Juanita, so when you become married, any previous will is void, and for that period in time you don't have a will. What happens when you separate or get divorced? Is it the same?
It's similar. It's not quite the same. And I should add that if you are getting married, it's not a reason not to do a will, because you can add a simple clause in your will saying that it's in contemplation of your marriage and it's effective. If you are in a relationship and have a will and then get divorced or separated from a de facto spouse, the will still remains in place and effective, but the bits in it that refer to that divorced spouse come out. So, for example, if you'd appointed them as executor, that will be ineffective and it will go to your backup executor. Or if you'd left your estate to them, that gift fails and then it goes to your alternative, your backup. So the will, it's almost like if you got a pair of scissors and cut their name out of the will. So the will still exists, but the references to that person come out. But it's important to still update it because, that obviously becomes a little bit tricky, and you want to make sure that what it says is what your wishes are in that circumstance.
Certainly, and being the eternal pessimist in regard to the things that can go wrong with estate planning. So the third scenario I'll throw at you is, so say you're married, the relationship's ended and you're now cohabiting with someone else. So you haven't actually got divorced, but you're now into a relationship, and you might be 2 years in a relationship with someone else, but you're still legally married. That scenario?
That gets really interesting. So therefore you have two spouses, and most people will say one is enough. So you would have your legally married spouse that you haven't yet divorced from, but if you've been in a relationship with someone on a de facto basis for 2 years, they are, in the eyes of the law, your de facto spouse. So look, that exact situation has arisen before the court before, and it can, for obvious reasons, can get quite messy if you pass away with two dueling spouses, especially if there's children involved as well. It even makes it trickier.
Yep. There's lots of lessons there, but the main one for what we're talking about is make sure you've got a will that's up to date, relevant, current.
One spouse is enough, and make sure your will is up to date.
Okay, there's 2 lessons.
Yeah, that's right. Bonus lessons today. So the next myth we'll talk about is, particularly with younger people, have a perception that I don't have any assets, so I don't need a will. Wrong. So what a lot of people don't realise is that a will, well, first of all, as I alluded to before, with a will you can nominate who administers your estate after you've gone. So without a will appointing an executor, that may be someone that you don't want it to be, because, again, the law will prescribe effectively who that will be. But it also makes it difficult for them. So what a lot of people forget is that even though they might not own property or have a lot of cash in the bank, they'll still most likely have superannuation, and in some cases life insurance. So most young people who are out of school or uni, been working for a couple of years, they might not feel they have a lot of wealth, but they'll have super. So this is, an example of something that needs to be addressed, and why you should have a will in place, because you want to be able to nominate who you would like to receive that super and have some control over it and some control over the process after you pass away. So,
sorry if I can just cut in there for a sec, because traditionally that's going to be $100,000, $200,000, $300,000 worth of life insurance, isn't it, for a young kid in a super fund, because it costs nothing to have that much cover. And so you then get into a tricky situation where if they don't have a will, and let's say they have, they're living with someone, and they might have been sharing a house with someone for a year or 2 or something like that, but their mum and dad have lent them a whole lot of money, there's always a risk, isn't there, that money could go to their de facto if they don't have a will, and not to other people they may owe money to, or brothers or sisters or parents or whatever.
Yeah, absolutely. And the interesting point there is, for the purposes of superannuation, you don't have to meet the 2-year test. So if you've been living with someone, for example, one year and 10 months, they are a superannuation dependent, and it may be that your super is paid to them by the trustee, or they may contest it. So that simply might not be what you want. In that circumstance, you may wish to leave a portion or all of your estate to your family, to your parents, to your siblings, or, as you say, there may be some arrangements that need to be addressed. So, it's almost like the opposite of the first myth we spoke about. I'm married, so I don't need a will. This sort of situation is a young person who may not be married, or may not have children, or may not have properties, etc. But the assumption that you don't need a will there is incorrect. It's advisable, because you will probably have super, you may have life insurance, you probably have a little bit in the bank, even if it's not a lot. You may have a partner who, even though you haven't been together 2 years, may be able to claim your super. You may leave behind a mess for your parents, because they will have to apply to the court to be appointed administrator of your estate. So for all of these reasons, you do need a will.
Yeah, what if the parents have guaranteed the $60,000 loan for the flash car, that sort of thing?
Yeah, absolutely.
They're the issue. Now, you missed one there. What was that second one?
I was saving the best till last. So.
Oh, okay. We'll save that one up now. Okay.
But let's talk about some misconceptions people have about contesting wills. So often I'll hear that someone, I'll use the example of a parent may not wish to leave something to a child for a particular reason. We may have a black sheep, or they may have provided for them in their lifetime, and they'll say, I'll just put something in the will. Someone told me if I just put something in the will, they won't contest. So that's a complete myth. And just by putting something in or giving them something in the will won't stop them contesting a will. Some people will think that by putting something in the will, they'll get nothing afterwards. So the two misconceptions here is a person who is eligible to contest a will is eligible no matter what you put in your will. So if you're a spouse, child, or a dependent, you can contest someone's will, and it doesn't matter if they've left you a gift of $1,000 or a gift of $5,000 or $10,000, etc. You are still eligible. The misconception that they won't get anything is wrong, because the test that the court applies, if it ever got to court, usually as we have touched on before, these matters often get settled, is whether that person has received adequate and proper provision from the will. So I guess my takeaway advice on this point is that it's a myth if you just put someone in a will or give them a little bit of something that they won't be able to contest a will, or that they won't receive anything. So, this is a really complicated area of the law, and it's where you need specific advice from a lawyer that knows their stuff, and make sure that your estate plan is appropriate. I personally believe that you should leave behind what you want to leave behind to someone, with the appropriate advice, knowing the risks and that may entail if they do choose to contest the will down the track. But of course, there's things we can put in place to minimise that risk.
Sure, and we've talked about this many times before, Juanita, and one of the greatest things you can do is to communicate with your children and your beneficiaries, spouse, and so on, in regard to what your plans are in general terms, because that's going to minimise the opportunity, or the propensity for a person to contest a will, is if they understand why it's been communicated with them. You can have the conversation at the time. It's normally, I would suggest, the surprise, isn't it, that would make people contest wills when they feel they've been slighted. Yeah. They don't understand why, and so on.
Yeah, that's a really good point. So here we go back to communication again. The thing we talk about every single week, it comes back to that. So certainly addressing those issues prior to one's death, I think, is definitely advantageous than leaving them to get a nasty shock. It might not even be a shock, but getting a shock or leaving it to the people behind to address and deal with the mess.
Yeah. Yep. And it's the lawyers that will win then, unfortunately, if there's a fight at the other end. And that's as we've talked about before, that's one of the greatest risks and the greatest opportunities to do something now, is to make sure you eliminate the opportunity for the dust up at the far end.
Definitely.
Okay.
All right, well, we move on to the next myth, and this is probably one of the most commonplace myths that I see people have when they come in to see us about their estate planning, and that is that all of my assets make up my estate. No, they don't. No, they don't. So we've already mentioned this morning superannuation. So that's the first one I will touch on. So superannuation does not form part of your estate unless you specifically nominate it that it does. So with superannuation, it's treated separately on your death. You have the ability to fill out a nomination form, a binding death nomination form, or preferred. There's different terminology, but basically a form where you nominate who you would like to receive your super, and it's separate to your will. It's a separate document. Only certain people are eligible to receive your superannuation. So a super dependent is a spouse, a child, or a financial dependent. So you can't leave your super to your sister or your cousin or your grandparents unless they're financially dependent on you. The final alternative, though, is you can nominate your estate to leave your super, and then it will go into your will and be dealt with in your will. But on a first instance basis, superannuation does not form part of your estate, which is left in your will. Most people have no idea about that. So it needs to be addressed appropriately at the same time that you do your will.
Yeah, and of course, putting it through your will then allows you to create protection around that asset too, doesn't it? Juanita, that's for another day. But that's, we've talked about testamentary trust before, but that's where you would use that nomination to your estate rather than to directly to beneficiaries.
Absolutely. So there's a lot of obviously a lot of wealth in superannuation these days. So by sending it to your estate, we can set up structures such as testamentary trusts and use all the benefits that they provide.
Yeah.
Another asset that is not included in your estate are jointly held assets mostly. So a lot of people don't realise this, that bank accounts that are held in joint names, so very common for married couples or couples in de facto relationships may have a bank account in both names. That bank account on one person's death will not form part of the estate left in the will. So it will automatically revert to the survivor, and the bank will effectively update the bank account name to the survivor. So that's an important thing to consider as part of your estate planning. Secondly, properties that are owned jointly as joint tenants, the same principle applies. So we can own properties with another person as joint tenants or tenants in common. Really briefly, the difference is that if you own a property as joint tenants, when one person dies, the other becomes the automatic survivor, automatic owner of the property, no matter what your will says. When you own a property as tenants in common, you literally own half the property. You could rule a line down half the house. You own half, and you can leave that in your will. There's different pros and cons about owning in either of those different ways, which all comes down to appropriate estate planning in your circumstances. But the bottom line is here to realise that that jointly held assets will essentially not form part of your will. Pros and cons. So that's why you need to go to a lawyer and discuss those types of assets with them. Probably the final type of asset I'll just talk about here that comes under that myth that all my assets make up my estate. Well, assets that you might hold in a family trust don't. They are owned by the trust. They are held on trust by the trustee of the trust, and they remain in the trust environment after you pass away. So if you have property, shares, you run a business out of a trust, when you die, you can't leave those assets in your will. What you can address in your will is the control of that trust and who controls it going forward. But it's very different to saying I leave my property on the main commercial road to X if it's held within a trust. So again, important to consider this and deal with those sort of assets appropriately. I guess that sometimes I will see people say after they've heard all that, again, why do I need a will then if all these things aren't forming part of my estate? And so that goes back to the initial couple of myths that we spoke about why you do need a will for various practical reasons, and the things that you obviously do want addressed in a will.
Yeah, just if I can touch back on when you talk about trusts, you can only nominate in your will what happens to the control of the trust if you're the appointor, I'm assuming.
Yes, correct.
Because if you're a trustee and you pass away, then it's up to the appointor to move on the control of that trust. So there's a fine distinction there, isn't there?
There is, and a lot of people aren't familiar necessarily with who the appointor of their trust is. They might be familiar with who the trustee is that deals with the administration of the trust, but the appointor or the principal, it's sometimes always also called, really has the power because they control who can administer who will the trustee be. So very, very important if you have a trust to identify who the appointor is and read the deed and find out what happens on your death and what can be done.
Yeah, just quickly there, for example, 3-4 weeks ago, I was dealing with someone who all their properties were held in trusts and in one trust. And for example, they've got 3 kids and they were telling me what they wanted to happen to each property. I'm going, well, time to see a lawyer here because, if you've got one trust that owns all these properties, when you die, it's the trust that will continue, not you can't allocate each individual property. So you'd have to obviously that you need some fine legal advice in that.
That's
situation.
right. From Murdoch lawyers, that's right.
Well, absolutely, Murdoch lawyers.
Or
you've
basically
dealt with
someone that knows their
succession
stuff.
solutions.
I guess that bottom line here is always you need the appropriate advice. And one final asset that that also doesn't necessarily get included, doesn't get included in your estate. You may have a company in place, and you may have assets owned by the company, but you can't just leave the company or leave those assets in your will. What you can leave are the shares you own in that company. And so, that needs to be addressed specifically, and also consideration given to who the directors will be of that company, because that ultimately comes down to the shareholders. So you can't just pass that baton over necessarily. So bottom line, it's important to have a will for the previous reasons, but it's important to realise not all your assets form part of your estate that is left in your will. So there's more to estate planning than a will.
Okay, so I'm going to intro for the next one here. Now, so I ran into someone recently that said, if any of my kids bloody challenge this will, I'm going to put it in the will that they're not going to get anything. How does that work?
Yeah, that doesn't work. So if you want to put in your will, I do not want Bobby to get anything. They shall receive nothing. For the reasons we touched on before, no, it just doesn't work, because the law says who can contest a will, irrespective of if you say in your will they can't. Some people might have said, can I say that Bobby gets 5,000, but if he contests, he gets none. No, nothing like that works. It is set by the law who can challenge a will and contest a will, irrespective of what you choose to put in a will. And often I would say those sort of emotional things shouldn't be put in a will, and the reason being, a will can become a public document if a grant of probate's obtained. I don't think airing dirty laundry in a will is appropriate, because there are a class of people who are able to get a copy legally and will if they ask for one. And you might not want people to read all that sort of stuff in a will. So I don't think it's appropriate, and it won't help.
So the trick is, if you don't want to leave someone money in your will, you make sure you spend it all the day before you go. Is that right?
That could be right. That could be right. But to be serious on that matter, another trick, there are ways it can be dealt with. So another trick, besides spending it all and living your best life, which you should be doing anyway, is holding assets jointly, which goes back to the myth we've just spoken about. So, if you are really concerned about someone contesting your will, a strategy could be to hold those assets jointly, or have them held in a trust, because they will not form part of your estate left in your will, and therefore the pool becomes smaller. So that's what I was alluding to when I say there are ways we can negate that risk, and you need to get proper advice.
Yep. Very good advice. And one final one.
I don't need a lawyer to do my will. I can buy a will kit from the news agency or download it off the internet. Now, obviously, when people hear me say that, they think, well, she's a lawyer. Of course she's going to say that. She wants them to go to her and pay money to do a will. But I guess two things. One, I hope after listening to what we've said today, we can see that there are lots of things that need to be addressed that won't be addressed by simply filling in the blank spaces on the form of a will kit that you buy at the news agency. I'll give a practical example that I've come across a few years back, where a gentleman got a newsagent kit, filled it out, and then thought he would add a few explanatory notes as to why he filled it out as he did. All that did was cause a lot more confusion about what his intentions actually were, and made it unclear. Therefore, the executor that was named in that will was forced to trot off to court to get the court to interpret what he was actually trying to say, because he had said that in his own words and made it more confusing. So the gentleman had thought he was saving money by going and buying a $30 will kit at the local news agency. By the time that the executor had got appropriate advice and had to make a court application to get the interpretation of the court, it ended up being a $30,000 exercise. So I'm sure that gentleman did not have that intention and did not want to see $30,000 come out of his estate, which basically means less for the people that he did want it to be left to. So that is a real case example, and that is why I would suggest to people that, sure, I'm glad that you're being proactive and doing something about your estate planning and wanting to put a will in, but it really is fraught with danger in case you mess it up or in case you don't deal with the things that we've spoken about today that a will may not deal with.
Absolutely. And look, one of those is, and I mean, I strike this occasionally, as you would, Juanita, is, I'm just reading here, one of my children has special needs. I'll leave it to my other kids to make sure she's okay. I mean, that is just stupid and dangerous on every level, isn't it? I mean, one is putting so much responsibility on your other children. If you have one child with special needs, it means for the rest of their lives, they're going to be managing that, but also there's a great chance that the money could run out, or you only need one other child to do the wrong thing, and so on. And you're not providing any certainty or guarantees for the needs of a child with special needs. So
yes,
and you're not going to be able to do that in a news agency will.
No, and I mean, a number of things jump in my head in that example that you say. So apart from the pressure on the child that you have given that responsibility to, it's quite plausible that siblings will fall out or their lives will move in different directions, and that child that you have asked to look after the other just has absolutely no legal requirement to do so if it's not specified. Another thing is by setting up appropriate structures such as special disability trusts as an example. There are a lot of financial and tax benefits that can be utilised for that child with a disability. And probably just thirdly, quickly before we run out of time, if that child with a special disability has a carer or another person that thinks that they've been hard done by, they may contest the will on that child with special disabilities behalf and say this is just not adequate for this child that has been left behind with a disability. We'll get a litigation guardian appointed and contest the will, and that there is recent case law on that matter where that has been successful. So great point, Mark, and not a good idea. Do not do that.
No, do not do the news agency will in that situation. And I mean, the other issues too. I mean, are examples where if kids have spending issue, one child might have a spending issue or a drug, alcohol issue, all those sorts of things. I mean, you're not providing protection for those children if you just go down and buy something at the news agency. I mean, you really need to put some decent thought into this. And I mean, the truth is, for the amount of money that most people have in their estates, even if it's just for young kids through superannuation, the insurance benefits through superannuation, I mean, it's just worth spending some money to get good advice and to make sure that the right money goes to the right people at the right time.
Absolutely.
Yep. Okay. Juanita, once again, a fabulous discussion and very interesting. I mean, we, there's a lot to cover in estate and succession planning, and, with your wealth of information and so on, it's once again been a very informative session. So thanks, Juanita. Have a great day, and thanks for everyone watching.
Thanks, everyone.